session. The Honorable Terrence J. McGann presiding.
Good morning, ladies and gentlemen. Please have a seat. Welcome to Courtroom 8C, better known as the People's Courtroom. Give me 1 second here. We'll call the case.
On case number C15CR24673, State of Maryland versus Karen Huger.
Good morning, Your Honor. Jordan Kramer on behalf of the state.
And David Martello on behalf of Ms. Huger, who is seated to my left.
All right, good morning. We do have more chairs from the jury room. If there's room for them in the aisle, it's fine with me, rather than people stand. Does anybody want a chair? Okay. If you do, adjust it. Before we, and take whatever you want. Doesn't matter where you sit. So before we start, I've been instructed that these proceedings will be recorded on Zoom, and that's fine. But the Zoom transmission must stay on mute, and the proceedings can't be recorded, and you can't interrupt the proceedings, no matter what you think. That's it for public announcements. All right, we're here for sentencing. I did order that both sides give me a sentencing memorandum. I received one from the state and the defense, along with the defendant's driving record.
Did you receive our supplements too that were this week?
I did not.
We sent courtesy copies.
Your Honor, there are packets on the bench that are
There's a few additional documents.
I'll be happy to look at them. Give me a second. Why don't you give me a second and I'll read them?
Sure, thank you.
Sure. These were submitted February 24th, right?
Yes. These were documents that we did not have because my client was still doing additional things after the 14th, when the first memorandum was submitted.
Okay. Today's the 26th. I just want to.
Yeah.
I wasn't sitting on them. Just got them. Okay.
Understand. Thank you, Judge.
All right. Okay. So just so we're clear, I read the letter from Reverend Dr. Robert Elliott Jr. from the Morning Star Baptist Church. It's a certificate of completion from sharing victims' stories to prevent drunk driving. And that's from Stacy Stewart, Mothers Against Drunk Driving, Chief Executive Officer. I read the report or letter from Sonia Howard, Case Manager, Beachside Private Recovery Center, and 6 degrees from Darlene Rowe. And it's the picture of empowering people after trauma. And PADD letter, and then a letter from Beachside Recovery, Suncloud Health, and from George J. Hazel.
Sure.
Okay. Is that it?
I think that is it. If there's anything missing, I will cover it in my allocution.
Thank you. All right, Mr. Martello, do you wish to begin?
Sure.
Sure.
Your Honor, as I prepare for today, I couldn't help but think about the reasons why we typically don't allow cameras in the courtroom. Many good reasons about things getting out on social media, concerns about how it may affect witnesses or the outcome of cases. But I think one of the largest reasons we don't want cameras in the courtroom is because of how it may affect the behavior of the participants. We want defense attorneys advocating vigorously for their clients and not so much advocating for the benefit of themselves out there in the media. We want prosecutors to be tough but fair and maybe not having to worry about what they say or don't say because someone needs to get elected a year or two from now. And we don't want judges necessarily to have to worry about their words and their words being taken out of context and being posted, short clips of videos and being criticized for making very hard, important decisions that go on in these courtrooms every day. It is just a fact of life when the cameras are rolling, people speak differently, they behave differently, they might say things they normally wouldn't say, and they may hold back information. It even causes me a bit of trepidation. In case you haven't noticed, this case has gotten some attention from the public. And there may be some people here that are truly interested in the outcome of the race, and I bet there's some people here that are just here to see the wreck in turn 4.
Here to what? I'm sorry.
The wreck, the crash in turn 4. And, you know, often when I allocute for someone in a DUI, I feel very free to talk about personal frailties, personal challenges. One thing I've learned doing this job in 30 years is nobody lives a charmed life. Nobody gets through years and years of life without some disaster. It might be a legal disaster, it might be a medical disaster, it might be a family disaster, but I don't think anyone lives a charmed life. And I think it is true that everyone we meet is fighting a battle we know nothing about. And therefore, we need to have some compassion for everyone we meet, even if we catch them on a bad day. Ms. Huger has certainly been in front of the cameras for almost 10 years through this show, Real Housewives of Potomac. And that is a show that clearly, if you've ever caught 5 minutes, and I don't expect you have spent much time watching that show, knowing the little bit I know about you.
You're quite correct. I've never watched it.
It is a show that is designed for drama. It is not edited to be a documentary, and I expect those editors aren't interested in seeing a discussion among the ladies about evaluating the best 4-slice toaster. They are editing this for drama, and the participants know it, the editors know it, and I expect when those cameras are rolling, people are a little bit more willing to say something that is gossipy or backbiting or promotes a little infighting and drama. It's probably good for the health and the popularity of the show, and I have no doubt it is that editing and drama that provokes all the attention that this case gets. But I have tried to express through my sentencing memorandum and here today that when the cameras are off, Karen Huger is first and foremost a devoted wife, a successful and committed mother, and as George Hazel puts it in his letter, he describes his aunt as a funny, kind, generous, and brilliant. And he hits the nail on the head when he says, unfortunately, the spotlight that shines on Karen Huger shines even brighter when her human frailties are on display. And that certainly has happened in this case. I think that spotlight may have contributed to how this case got resolved or didn't get resolved and why it went to trial. I suspect that there may have been some paralysis in decision making that was caused by that spotlight. You know, I know you were in private practice long ago, and I'm sure you remember the client. There might be offers and compromises on the table to consider that you may have recommended that were good. They still come with some downsides, right? You're still giving up something. Any compromise involves getting something and giving up something. And there are some of those clients that just can't get to that point where they want to throw in the towel and say, okay, I'm going to resolve it this way. I'm going to take what is behind door number 1, because door number 2 is a trial, and that trial still offers the hope, even if it's small, it offers the hope that something almost miraculous is going to happen, and this is all going to go away, and it's going to go away successfully. And I suspect that, along with the overuse of prescribed medication, may have led to this case going to trial, and maybe a case that really never needed or should have gone to trial. But I have a feeling you're going to hear from Ms. Huger that there were some benefits to her personally in having that trial. So I get into this case in January, and there are some things that are obviously of concern to the court. One, I know it's of concern to the court that this was an accident, right? That's a little bit more serious than just driving down the road and Officer Friendly pulls you over for weaving across the double yellow line. Certainly, Ms. Huger is very lucky and thankful that a sign got hit, and as the state points out, it was not a pedestrian, it was not a cyclist, it was not another car that was occupied. Fortunately, we can stand here to say the only thing that had to happen after this case was we needed to fix stuff. We needed to repair stuff. We did not need to mend people who were injured. The state emphasizes, and the court may have concern about her demeanor at the time that she was arrested. And again, I think maybe the public spotlight could have contributed to that. I am sure Ms. Huger, when the police show up and they start asking her questions and realizes that they're not just going to give her a ride home, we're going to stop by the station first. I know that was very upsetting and stressful, because she knows this time this is going to go out to the world. This is not just her own private difficulty. This is now going to be news of the world. And I have no doubt that that probably contributed to maybe some instances.
I was paying attention.
Sure. May have contributed to some condescending comments, or maybe some behavior that the state might want to describe as arrogant, but I don't think she ever was belligerent and ultimately followed the guidance of the officers. I will say, in my conversations with Huger, she expressed great regret about, having watched the cameras, having gone through the trial, about her demeanor that night. And I said to her, okay, well, why don't we put it in writing? Let's let the officers know. So I've provided the state. I just want to hand up to you. It's 3 pages, but it's all the same thing. She did send back earlier this month, if I may, letters of thanks and apology to the officers for their service that evening. You look like you want to ask me a question.
No, I want to stop at a logical spot before I read these.
Sure.
This might be the time.
Yeah, I'll pause.
Okay. So I've been told that someone is live blogging the proceedings on reddit.com. Now, I don't know what blogging is, and I don't know what Reddit is, but I have heard of the internet. So if you're doing that, don't do it. I guess that's tantamount to recording the proceedings, I guess. So I'm just
Can I approach
throwing
with the
that
state?
out.
May I approach with the state? Can I approach the bench?
Yeah,
With the state?
sure.
Yeah, I'm very concerned about this. I have had cases where judges collect everyone's cell phone and put it in a box, and they get it afterwards.
Yeah, I'm like the farthest away from a judge that does that.
I understand.
Yeah.
Okay.
I just tell them to limit their calls to 3 minutes if they get one. But other than that, I'm not a stickler on that, because I know their phones are like an appendage of people's arms, so, but I'm
Would you instruct that no phone should be, invisible?
No, I mean, what's the, it's kind of interesting, isn't it ironic, coming from I guess your clients is very open and public, as you indicated. What is the concern that you would have?
Well, I guess I just want to follow what has been like the practice of this court.
Right.
That these things are not to be recorded.
Right, yeah.
As the official record. But
I agree with that 100%. Justin's pretty good at monitoring this stuff. I give him credit. I don't know how he did it, but you might want to apply for a job with Doge. I don't know.
That's fine, Judge. That's fine. I just
No. I threw in a little levity, but it's serious. I agree with you. What's the state's position? Yeah. Just turn them off, and then when they leave, how's that? Okay. All right.
I appreciate it.
And yeah, sure.
Ladies and gentlemen, here's a silly question. Here's the state. If anyone has a cell phone, please turn it off. When you leave and the proceedings are over, you can text, email, make all the calls you need. But during the proceedings, we'd ask that you turn them off. That's all. Please do that. Thank you. And some of you maybe have forgotten, so just check it. And thank you. Okay. Mr. Martell, I'm going to take a look at what you just brought.
Thank you.
Gave me. Sure. And the state just got a copy too?
I have a copy.
Okay. This is from your client.
That's correct.
Do you want me to read it to myself or out loud?
To yourself is fine, Judge.
Okay. Okay, so this is written to Sergeant Brett Trahan, and I'll read it to myself, correct?
Thank you.
Okay, but that's who it's written to by your client.
To the three each one went to
okay.
3 officers.
I got you. Okay, thank you very much.
Okay. And then, of course, you are concerned about her record. And here's what we know about her record. She had a 2006 event that was resolved in September 2007 with a PBJ for driving while impaired. There was a 2008 event that started out as a DUI, and that was resolved as a reckless driving. Now, Ms. Kramer and I have a bit of dispute about the 2010 event, okay? And it is really only important as far as the subsequent offender penalties. If that 2010 event is a driving while impaired, then the maximum penalty the court can impose in this case is 1 year. If it is driving under the influence, then the maximum penalty is 2 years. And Ms. Kramer and I both have gone or requested the courthouse in Greenbelt to give us documents about that to try to figure out what it is. And I'm going to pass up a few pages that I've given to the state. They actually originally gave me these documents, and I want to show you why it's an issue. So the first page you'll recognize is a copy of Ms. Huger's Maryland driving record. And I've highlighted September 2010, driving while impaired by alcohol. The next page is a document the state provided me. I haven't really ever seen this before, but it's what's called a complete Maryland driving record. And this document, too, also says driving or attempting to drive while impaired by alcohol. It has a citation number, a statute, the violation date, and that's pretty consistent with the driving record you have on the first page that you're used to seeing. Now, the next 2 pages are documents that Ms. Kramer and I both were able to obtain from Greenbelt, but it seems to be all we're able to obtain, believe it or not. It is a list of citations, and I've highlighted the May 10th, 2011 disposition date, paid $35, has the word mandatory PF, citation number, and then the next page is something called MAGBASE from the United States District Court for the District Court of Maryland, and it says DUI. It seems to have that corresponding citation number, and that's all we can get. Like, I was really surprised and disappointed. We couldn't get a docket sheet, something handwritten by the judge. This was all, and this little chart here looks like something created by a 3rd grader. Like, doesn't look like an official court record that we're normally seeing. And my concern is that this might be a summary that was generated by a program or something capturing information from the case or an electronic database. But what you do know is that what was transmitted to the Maryland MVA back in September 23, 2010, is that the disposition that was communicated to the MVA was driving while impaired. And I don't know how that would ever happen if the final disposition of that case was driving under the influence of alcohol. I do want to point out that the state says, well, there's no such thing in the federal court as driving while impaired. And that's not correct. I'm going to disagree with the state there. So in the federal court, they absorb, for purposes of traffic cases and DUIs, they have what's called the Assimilative Crimes Act, which relies on Maryland state law to prosecute crimes that happen on federal property. And just to verify this, I just went into LexisNexis and I look up 4th Circuit, driving while impaired, and all sorts of cases come up, including United States versus Castro, a 2023 case, and it just mentions in the facts that Mr. Castro was pulled over and charged for driving at Fort Detrick for driving under the influence of alcohol, driving while impaired by alcohol. So that crime can be prosecuted in federal court. A DUI can be amended down to driving while impaired. That could be the disposition. Again, this is of consequence as to the maximum penalty involved, whether the maximum is 1 year or 2 years. I think the only reliable information you have in front of you is the final disposition, the disposition that was communicated to the Maryland MVA that they have as her driving record is driving while impaired by alcohol. But regardless of what that is, certainly she has a record. This is not a garden variety first offense. So what has Ms. Huger done? Whenever a client comes to me with a record, I know the court wants to know about accountability, responsibility, rehabilitation. And I often think that there are 2 kinds of accountability. There's accountability that the court imposes, and there's accountability that a client takes up for herself, okay, and executes and imposes on herself even before we get to court. And I would say over the long haul, the most important accountability is what the client does to herself and for herself, because that is not forced upon her. It is something that she recognizes is important, that is important for her health and her future. And look, no doubt this happened because the outcome of this case, because you're the one sitting in that chair, and we've got a very good prosecutor wanting to hold her accountable. But you know there's a lot of clients that don't step up to the plate and do the things they should be doing for the community and for themselves. So when I got the call from Ms. Huger that they would like me to be involved in the case, she was already packing her bags to go to this beachside recovery center in West Palm Beach. which she spent 31 days there. And the reason she picked that program is because she felt, and people advising her felt, it was the best program to take care of 3 issues. 1, her abuse of antidepressant, anti-anxiety medication, her use of alcohol on top of that medication, her own mental health, the underlying depression and anxiety that caused her over the years to use this medication, and then also the underlying, still unresolved, to a certain degree, trauma of being a rape victim many years ago when she was a student at the University of Virginia, the event that ultimately caused her to withdraw and take a different path in her life. And I understand the state may want to suggest to you that, well, this was a very comfortable place. When you look at the website, you know, there's an image of a swimming pool and people meditating and things like that. But this is, as you have from the letters, this is a true, hardworking program. And I think we have to be honest to all of ourselves. These businesses, these programs, they want to get people to come. And you're not going to get people to come if the picture on the front of your website is a cinder block room, okay, or people lined up with a metal tray to go get lunch. They want people to get into the programs. And these are often people who are frail, who are reluctant, that maybe are the product of it's a product of an intervention by family to really get them to go. And so it is necessary that there be something attractive about going and taking yourself out of circulation, taking yourself out of your job, taking yourself out away from family and friends, and going to work on some really hard issues and cut yourself off from the substances and the things that have gotten you through day to day. This is a state where the people of Maryland, through the legislature, have made a number of changes about how we approach addiction and drug use and drug possession. We've gotten rid of mandatory minimum sentences for felony drug traffickers. We have reduced the eligibility of parole for certain felony drug offenses from serving half the time to serving 1/4 of the time. We have created the Justice Reinvestment Act, which wants to place an emphasis on treatment rather than incarceration and in punishment. The legislature several years ago even went so far as to reduce the penalties for possession of non-marijuana, possession of heroin, opiates, cocaine, crack, reduce the penalties from 4 years to 1 year. Emphasis on getting into treatment. And getting people into treatment is hard. We don't prosecute a lot of those crimes like we used to back in the 90s and early 2000s. And even though we place that emphasis in treatment, the people who do this job know it is hard to get people into treatment, okay? Deaths by overdoses are going down, but we know when we read the articles carefully, a lot of it is not because people are getting into treatment, it's because officers are coming back to the same house over and over and applying Narcan. So whatever you have to do to get people into treatment is going to be healthy and positive, and it's not always easy. So Karen Huger selected this program. It is a meaningful program, and it has produced tremendous events. She went through a struggle. It was 4 days of withdrawal. I had mentioned that she woke up on the 4th day completely soaked in sweat. Her bed was drenched in sweat as her body got separated from that dependence on the antidepressant medication. And over the course of the next 28 days, worked on deeply meaningful personal issues, 35 hours a week of group counseling, and then on top of that, individual counseling. And you have a letter from her therapist. She still has a relationship with her therapist. She will continue with that relationship remotely, weekly, with that therapist to make sure she stays on the right track and continues on a track towards progress. However, I understand. I know who I'm sitting in front of, and you may want to have Miss Huger experience something that is a little grittier than a rehabilitation center in West Palm Beach, which is why I recommended, and she very willingly completed the weekend intervention program at Right Turn. You didn't mention that letter. I thought I did submit it. She was admitted on February 14th, and she was successfully discharged on February 16th. So Right Turn Impact is a rare program that does try to replicate a jail-like setting. You go in on a Friday, you come out on a Sunday. They take your phone from you. You don't have your phone during that weekend. And I can pass up another copy, Judge.
Sure, thank you. No, I didn't mention it, because I didn't have it. Now I do.
Okay. It was filed last week.
Okay, thank you. Thank you, Gene.
So, unlike a lot of rehabilitation programs, they put you in a room with 10 other residents. You bunk, one on top of another, lights out at a certain time, wake up at a certain time. The food's not great. I've often had clients tell me, look, I just stuck with the potato chips. I didn't really eat anything else there. And then while you're there, unlike a jail setting, you're doing counseling groups and AA meetings to pass the time. But that gave her a taste of what it's like to see the inside of a jail. Additionally, Right Turn always encourages the clients that come through there to create a binder and have a binder. And Ms. Huger comes to court today with her binder, which they encourage to keep track of everything that she has done for her recovery. Her beachside certificates, her reports, the program requirements, AA meetings, Right Turn Impact, letters of support, whatever she's doing. And this becomes kind of like another tool of accountability, whereas if she accomplished it, it goes in the binder. Don't lose track of the binder, because it is important to look back on what you've accomplished and that you stay focused on the right path. So this is something that she will continue to maintain. There are other important things that we typically like to see here in Maryland clients do to help along that element of deterrence and rehabilitation. For example, she has completed a Mothers Against Drunk Driving Victim Impact Panel. We have submitted that certificate. And I even had her do the PAD class, which stands for Positive Alternatives to Dangerous and Destructive Decisions. This is a program that is run by Corporal Rector of the Frederick County Sheriff's Office. And it focuses on DUI cases and any kind of reckless driving case. And what they do is they have people who have been seriously injured in DUI accidents. They have people come who have killed people in DUI accidents. Sometimes they will have surgeons come and show with video what it is like to go through, what the surgery is like if there's someone who is critically injured in a DUI. And the whole idea is it's supposed to give a lasting impression of how lucky someone like Ms. Huger is to have not have harmed someone, and to think about it every time they press that start button on the car. Think about the potential consequences. It's a little bit more scarier and more traumatic than even the Mothers Against Drunk Driving seminar. She will be starting this week the SunCloud Health intensive outpatient program that is very similar to Colmac Clinic. She did have to undergo a medical procedure last week, which delayed her enrollment in that program, but she had her first intake meeting last week. Her first week in that IOP will be 6 sessions, approximately 4 hours long each sessions. The second week will be 6 weeks, and then it's like 4, it tapers off, 3, 2, and 2. And then after that, there will be an aftercare program. So that is a significant follow-up to her inpatient treatment. She has been attending the AA group, AA coffee group at 8 a.m. every day. And now that she has done the medical procedure and is getting settled into the IOP, she will be attending an AA meeting in Bethesda. I'm going to hold off on identifying the actual name, so like people don't show up and start wanting to go all of a sudden with their phones and cameras go to that AA meeting. She will be participating in the interlock program, and I probably bored you to tears for a page or two explaining the interlock in my memorandum. So what happens is, one of the charges was not having a Maryland license after moving to Maryland. She had a Virginia license, and that's a relatively minor violation, but if the attorney doesn't think to tell the client, it often doesn't come up. When a client comes in the office, there's so many things they're worried about, there's so many things you're talking about, and sometimes it doesn't even come up that, well, you have this out-of-state license and you need to get a Maryland license within 45 days before that temporary expires. Because once you get suspended for that refusal to take the breath test, you're going to have to serve that out. Maryland's not going to let you have any kind of license, okay? Change that Virginia to Maryland until you serve out that suspension. And that's what she had to do. She had to serve out that 9-month suspension. When I spoke to her, I said, look, make sure you get this done, because there's a new law that went into effect in Maryland on October 1st. Everybody who gets a DUI, a final disposition in court, whether it's a PBJ or not, is going to have to do the interlock for 6 months, and I expect you're going to impose it as a condition of that probation. But now that she has that license, she can participate in the interlock program in Maryland. And then I want to tell you about another thing that you may not often hear about. So she has signed up to participate through a program called Alert Home Detention. It's something called SoberLink. This is a handheld breath test device. The director of this program, Tim Schlau, is in the front row. He's here today. There is a tube that goes in here. There's a camera right here. This program will require her to blow into this device several times a day. And the reports of the results can go to anyone you desire. Probation agent, they can come directly to your email. They will go to Mr. Schlau's email. And as I said, certainly the probation agent. So if she consumes alcohol while she's on your probation, someone's going to find out about it, and it can be a violation. I guess 99% of the time, we tell probationers completely abstain from use of alcohol, and we hope that they go do it. In the privacy of their own home, we may never know, okay? Alcohol metabolizes out of the body much more quickly than cocaine or marijuana or things of that nature. So unless you're testing people rapidly almost every week, it's hard to detect if someone is doing it. But this is a way now to know if your probationer is using alcohol at any time. It costs money. She has the resources. She's involved in that. She took her first breath today on this device. If you think that there is some more punitive measures, and again, we do ask you to consider, it has been 15 years since her last event. Okay? If you think there needs to be more of a sting of punishment, I would ask you to consider home detention. In addition to this program, Mr. Schlau and his company, they do provide for many defendants around the state, for many courts, a home detention service where she'd be wearing a monitor. She'd be limited to going out for work and for legal visits or medical appointments. Mr. Schlau has provided me with an order for you to sign if you care to put her on that home detention. I would ask for that home detention in lieu of a period of incarceration. I did mention in my memorandum an issue with the failure to control speed to avoid a collision. Again, I recognize it's a minor offense. I don't believe there was anything in this case that involved striking another conveyance. I think she hit a curb, a sign, maybe a tree. If I had been involved, I probably would have made a motion for judgment of acquittal on that. If you don't grant that belatedly at my request, I'd ask you to merge that, indicate that that sentence is merged into some other offense, so it does not appear on her record. At this time, would you allow me briefly to call up Ms. Huger's husband?
Sure, take her, yeah.
If you could come up and stand next to me.
If he wants to testify, he can do that, or he can stand there, your choice.
This will be brief. I think I can just have him stand right here. In a loud, clear voice, tell the judge your name.
Raymond Huger.
Good morning, sir.
Who are you to Karen Huger?
I'm a husband of 28 years, and I've known her for 30 years.
And do you have any children with Karen?
Yes, we have a son and a daughter.
Okay.
The son is 37 years old, and the daughter is 27 years old.
And are they doing well, successful?
They're doing very well. They're doing very well. They're both very well educated and very successful in their chosen fields.
You are aware of everything Karen has done in the last few months regarding her recovery, is that right?
Yes, I'm very aware of her, I guess, rehabilitation or treatment center. I actually had correspondence with a therapist. I talked to a therapist on the phone several times while she was away. I also exchanged emails concerning her progress. And actually, they were pleasantly surprised at how thorough she was and how anxious she was to complete the program and how she participated and worked very hard. I don't know if they wrote that in the document, but that's what they told me verbally.
And tell the judge, how is she doing?
She's doing very well. I mean, I'm actually surprised because it was such a traumatic incident, and I was scared to death, because of the accident. But she's recovered. It's been a year since that time, and she's actually dedicated herself to looking forward to helping others and not have this situation happen to them. She's also have gotten closer to God and, talks about her faith a lot more than she had in the past. She's certainly very remorseful for the incident and certainly feels like it's something that really woke her up and turned her into a little different person. And as far as I understand, I don't think she's had a drink at all since that incident occurred.
The judge today is certainly going to order your wife to perform a number of conditions, maybe for years. What can you tell the judge about Karen's willingness and ability and the confidence you have that she's going to follow through on every one of the conditions the judge may impose?
Oh, I'm very confident that she would follow through. She's tenacious and executes well if she understands it's something that she thinks is important to do, and I'm sure anything that you prescribe would be something that she would consider to be very important to do. She's a self-starter. She was a homemaker but became an entrepreneur and opened up several different businesses, which would take a lot of energy and dedication to do that kind of thing, and she's been successful in those endeavors. And just like the people at the treatment center said, that she's very anxious to become the new person and move forward from where she had been before.
Is there anything else you want to say to the judge about what he should do today?
Well, I want to first thank the judge for the opportunity to speak.
You're welcome.
I appreciate that. I also, when I look at all that she has done since that time in terms of actively participating in various programs. Now, she actually wanted to go away early on last year when the incident occurred. However, she was just at the beginning of taping the show, and it was a weird situation, so she felt obligated to continue with the show, and when that taping period ended is when she did go away. So she certainly wanted to get help, and she has gotten that. She's gone to AA meetings, as you mentioned, the Right Turn program, the 28 days away, as well as a lot of group therapy. And with all that she's done at this point, and I'm proud of her and what she's done, and I also feel that she's really learned her lesson, if you will, and has done everything that she could to improve herself, and certainly not drinking for this period of time is something very positive. So I would ask the judge for a leniency in the sentencing based on what she's done already. I think that doing time or incarceration would not benefit her that much. She's sort of seen what it looks like, if you will. But I think that what would benefit society is her being available to be a spokesperson for not drinking and driving, not mixing medications, being careful with that, as well as being an advocate for seeking mental health if that's something that makes sense to do. So I think she would be far better in terms of helping society as well as herself, and by being available to be an advocate and using her platform to be very positive about preventing people from drinking and driving and using medications and health advocate, if you will.
Understood.
Yeah.
Thank you very much.
Well, thank you.
Thank you, sir. Appreciate it.
Your Honor, I think most people in this world establish a career. They go to work every day. They want to make good wage, good income. They provide for their families. They want to enjoy success, and they want to enjoy the indulgences of being successful that life brings. And many people do all of that, and very little or maybe no part of their lives are dedicated to helping others outside of their sphere. Ms. Huger has been able to enjoy success, but has also used her success to promote causes that help others, causes that are important to her, whether it's survivors of sexual assault, people struggling to help a relative dealing with dementia or Alzheimer's, helping mentor children in her community to be successful professionals. During COVID, providing masks to first responders, providing backpacks to children in various communities of the state. She is a good person. She has been gracious through this experience in dealing with me, and I can tell you she has been willing to follow every recommendation that I have offered to her. And she has accomplished a lot in a short amount of time that I have dealt with her. And because of that, I think the court can have confidence that the prognosis is very high, that she's going to successfully complete whatever probation you impose upon her, and that we have achieved various interests that come from a case like this, of deterrence, of rehabilitation, of accountability. Given the passage of time and her good works and her commitment to her recovery, I'm going to ask you to impose a suspended sentence. I recommend 3 years of supervised probation with a condition that she successfully complete the SunCloud Intensive Outpatient Program and any recommended aftercare program. I recommend that you order her to complete 2 AA meetings per week for 52 weeks, that she obtain a home group and a sponsor. I'm going to ask you to make it a condition that she continue in individual therapy. I expect you will order her to install the interlock on any vehicle. And I'm going to ask you to impose a condition of probation that she participate in the SoberLink alcohol monitoring program. Again, I am asking that you impose a suspended sentence. If you think that there is any stricter requirements that should be imposed in this case, I would ask you to order her to serve a term of home detention through the Alert Home Detention Program. And I thank you.
Thank you, Mr. Martello. Appreciate it. Ms. Kramer.
Thank you, Your Honor.
You're welcome.
Your Honor, Mr. Martella started his presentation by referring to when the cameras are on and maybe Ms. Huger was caught on a bad day. Your Honor, this was not one bad day for Ms. Huger. This is a pattern of conduct that has been going on for roughly 20 years. She picked up her first DUI offense in 2006 here in Montgomery County. She received the probation before judgment on that. 2 years later, or I think it was 1 year later, 2007 or 2008, she picked up another DUI or DWI offense in the Eastern District of Virginia. That was pled down to a reckless driving. And then again in 2010, the DUI that she had out of the U.S. District Court here in Greenbelt. This is a pattern, Your Honor. Ms. Huger has done a lot of things, and I think that's great. She has done a lot of great programs, things that the state would have wanted her to complete. The AA, the treatment centers, the right turn. These are great programs that she needed to complete. However, it is striking to the state that she did not complete any of these programs until being found guilty for a third time of an impaired driving offense. I've heard nothing from the defense that she had completed any type of alcohol counseling or treatment or program after the first DUI or after the second one, and not even after she picked up these charges a year ago in March of 2024. She didn't do anything to rehabilitate herself until after the guilty verdicts came back in this case in December of 2024. Ms. Huger did go to a wellness center back in August, pre-trial, the Miraval Resort. I did look into that resort. It had 0 alcohol rehabilitation services to offer. It was quite simply a spa, a wellness center. So that's what she did pre-trial, and then it wasn't until this guilty verdict came back in December that she enrolled and got the wake-up call, I guess, to enroll in this beachside recovery. I addressed it in my sentencing memo, and I don't want to repeat myself, but the state also does have concerns that when she did choose to enroll in a treatment center, she enrolled in one that the website even touts itself on equating it to a luxury 4 or 5-star hotel experience. And I understand, as Mr. Martella indicated, when people are going through rehab, they want to be in a setting that's comfortable, and I understand that. But Ms. Huger has now, this is her 4th driving while impaired, driving under the influence offense, and it does not appear to the state that Ms. Huger has taken this seriously. Your Honor, I've seen what appears to the state as a pattern of deflection from Ms. Huger ever since this incident occurred in March of 2024. On scene, and Your Honor saw from the body-worn camera footage, on scene, she blames the accident on a car. She says she was ran off the road. That turned out not to be true. There was no evidence of that or no testimony of that. That's what she says on scene. She makes another statement about that publicly right after the accident, saying another car headed straight for her, and again, deflecting blame from the collision. And now in her sentencing memo, it seems there's more deflection of not admitting fully that she has a problem with alcohol, but rather blaming it on mixing alcohol with these antidepressants. And, Your Honor, I would like to note from the sentencing memorandum, Ms. Huger has been taking these antidepressants for, seems like, decades. It's not as if, I understand the dosage may have changed, but it doesn't appear to me that this is a new prescription that she just started on right before this event and didn't know the effects. It seems as if she has been on this medication for decades and should have known better. So again, Your Honor, it just seems to be a pattern of continued deflection from Ms. Huger and a continued pattern of not fully understanding the gravity of the situation. From her prior 3 instances, she has served 0 jail time. She received the PBJ in 2007. The 2008 event was pled down to a reckless driving, which was just a payable offense, I believe. And then the 2010 DUI, she did actually serve 18 months of probation on that. I did learn that recently from the clerk from the Greenbelt District Court. But she has served 0 jail time. And quite frankly, Your Honor, it's gotten to the point when you've received your 4th driving under the influence offense, something has to give. And the state is concerned that she has been given those 3 chances. That's part of the reason we have a probation before judgment in Maryland, is we understand, and the state understands, people are entitled to a second chance. But this is not Ms. Huger's second chance. This is her 4th incident. She has gotten her chance on 3 previous times and has learned nothing. I'd also like to bring up to Your Honor that shortly after our verdict in December, Ms. Huger did film a segment with her producers from the show, in which that was later released. It was just released a few weeks ago, in which she stated she's not an alcoholic, but rather, again, saying that the problem is these antidepressants with the alcohol. And I bring that up just to say, Your Honor, that I think that there is a problem with Ms. Huger, again, not taking full accountability of what is going on. If this was her first incident, I can see how maybe she would, go along that route. But when it's your 4th DUI, there is a larger problem. That, again, I just don't believe that Ms. Huger is fully appreciating. I will briefly address the issue of the 2010 DUI. We do have a printout of a docket sheet. Mr. Martella and I have tried endlessly to get any type of record from the Greenbelt District Court. I've talked on the phone with several people. I've requested it. Because of the age of the offense, they said they don't keep computer records from offenses that are that old. And of course, the physical files get destroyed after some time, and this event is 15 years old. In my supplemental supporting exhibits that I can send a courtesy copy to the court, and it was filed again on Monday, I believe, the last page of that does have this docket sheet, and I can pass this up to Your Honor if you don't have it in front of you already, where it lists the offense as DUI alcohol. I understand that on her Maryland driving record, it shows through as a driving while impaired, but it was a federal offense that she pled guilty to. From my understanding, the United States Code titles it as a DUI. The United States, the federal code does not distinguish. There is no federal DWI. I understand that maybe you can have a state DWI that's processed through federal court, but there is no federal DWI. She pled, in my understanding, to the federal offense, which is a driving under the influence. So from the state's perspective, this offense, while it did note on her driving record as driving while impaired, it is a driving under the influence event, which would cause those subsequent offender penalties to be in play for that 2-year backup time. And does Your Honor have the copy of that? I can pass up.
I have the copy of the record you gave me.
Yes, and on the last page is the docket sheet from
Yes,
that.
I have that.
Okay, perfect.
I've reviewed it.
Thank you, Your Honor. Your Honor, as Your Honor is well aware, we have certain purposes of sentencing: deterrence, rehabilitation, and punishment. And I understand that Ms. Huger has made tremendous efforts to rehabilitate herself, and those are, again, things that the state would have wanted her to complete, and we are glad that she has completed them. But I do think by the time you get to your 4th DUI offense, there does need to be some level of punishment. We saw, her statements on scene of just this very entitled behavior of making statements that this is never going to touch me, and you should Google me. You're going to be ashamed of yourself when you find out who I am. And I just don't think, the state does not think at this point there has been enough accountability for Ms. Huger. She has done this on multiple occasions before, and each time she walks away with a no jail sentence and maybe some probation and some fines. And as we can see, she has done it again. So the state does believe at this point that something has got to give. She's been given the benefit of the doubt 3 times before, and nothing seems to have changed. So, Your Honor, the state's recommendation at this point would be to sentence her to the 2 years of backup time, suspend all but 6 months of active incarceration. We would ask that Your Honor place her on supervised probation. We would ask that the interlock be a condition of her probation, as well as continue in the treatment programs, the AA. I understand she's already done the MAD Victim Impact Panel, which is something the state always recommends as well. But we would ask for the 6 months of executed incarceration at this time. Again, it was a collision, as Mr. Martella indicated. This is not simply driving down the road, speeding a little bit, or swerving. This was a collision where her car it started to smoke. It was inoperable. And she's extremely lucky that she did not hurt herself nor anybody else. And the state does not believe at this point that Ms. Huger has fully appreciated and taken accountability for her actions at this time. And that's the state's recommendation.
Thank you, Ms. Kramer. Ms. Huger, is there anything you'd like to say before the court imposes its sentence?
Yes, Your Honor.
All right, I'll be happy to hear from you.
I prepared a statement. Didn't want to forget anything. Your Honor, I want to apologize for taking this case to trial. But I also want to thank you for allowing me to have the trial. I think it was the mirror I needed to take a hard look at myself and the direction I was headed in. I think my prior cases, I showed up to court, followed the advice of my lawyers, got the case resolved, and went my way. I like to think I took the cases seriously. But this certainly has been such a much different experience for me. An experience that demanded that I take a look at myself, truthfully. I think for many years I was putting a Band-Aid on some personal history that was leaving me very unhappy. It is possible that just like taking daily medication for high blood pressure and cholesterol, I just thought medication for depression and anxiety was something that came with the territory of getting older and having more responsibilities and more to worry about. And certainly there was a sense of entitlement that I should be allowed to keep on consuming alcohol. I have been successful. It's been 15 years since my last DUI. Why should I give up the social indulgence? Well, this case is why. Drinking responsibly, especially while taking medications, mean not drinking at all. I failed at that miserably. I understand how lucky I am that I hit a tree. Thank God I did not hit a pedestrian. In recovery, I was told of a young man named Kevin who hit a tree when he was 17 years old. Kevin was in a coma for 30 days. Kevin is now permanently brain damaged and his life will never be the same. I asked God, why not me? The only answer I could come up with was that I was spared because I have a responsibility to use my unique optic lens and teach others and affect quite possibly millions of people with the message of not drinking and driving. I understand better the brutal clarity of the fact that when you're behind a car driving, you're not just driving for yourself. It's my responsibility to make sure my community members make it to their destination safely as well. I want to thank the officers who came to my assistance that night and apologize for my attitude back on March 19th. They were truly professional and gracious toward me at a time when I was not. The body cameras definitely prove that they were right and I was wrong. I should have handled the situation differently. Your Honor, I have a lot on my plate now, but I understand this is all for a very good reason. I will not let you down. I will not let my community down. I will follow through on everything I am currently doing to maintain my sobriety and everything you ordered me to do. And I can assure you that AA is going to remain a part of my life for the rest of my life. I will graduate out of programs, probation, and interlock terms will end. But I know that the relationships that I am creating with AA could and should and will last a lifetime. Those relationships are the greatest offer that I can offer you of my terms of sobriety and success. Thank you.
Thank you, Ms. Huger. I appreciate your comment. Karen Huger was convicted by a jury here in Montgomery County of driving under the influence of alcohol. What does it mean to be under the influence? It means that she was affected or altered by the use of alcohol. Before Ms. Huger was arrested, she refused to perform simple physical coordination tests. After she was arrested, she declined to allow the police to administer a breath test to determine the level of alcohol in her bloodstream. Both the coordination test and the breath test would have served as objective evidence as to how much the alcohol she had consumed had influenced her on March 19, 2024. However, the policeman's body-worn camera video at the crime scene provided proof positive of her inebriated state. Ms. Huger consumed so much alcohol that she drove at an exorbitant speed as she entered a quiet, sleepy Potomac neighborhood. She drove so fast and her coordination was so compromised that she flew her car onto and over a median where it sheared off a pedestrian crossing sign and spun around, slamming into a tree and landing on the grass. The impact was severe enough to crumble the front end of her Mazda and leave Miss Huber pinned behind deployed airbags in a drunken stupor. Miss Huber stumbled around the newly formed accident scene. Her eyes were wild and wandered, focusing neither on the paramedics nor the police as they endeavored to ascertain the causes of the accident and her physical condition. Despite her alcohol-induced confusion, they persisted in trying to engage Ms. Huger. Her speech was mostly unresponsive, evasive, and slurred. Her disheveled hair and clothes inexplicably never seemed to bother her. Ms. Huger demonstrated drastic mood swings. For example, one minute she was telling paramedic Han how pretty she was, and the next minute she used a crude phrase to dismiss her. She babbled incessantly as she was being driven to and while at the police station. Ms. Huger's bizarre behavior and demeanor were the result of her choice to consume excessive amounts of alcohol. The jury has found the defendant guilty of driving under the influence of alcohol, negligent driving, failure to reduce her speed, and failure to notify the Motor Vehicle Administration of her change of address in 30 days. So what is the appropriate sentence? Karen Huger is no stranger to driving drunk on our public roads. In 2007, she was found guilty of driving while impaired by alcohol here in Montgomery County. She was afforded a sentence called probation before judgment,
which prevented her from receiving a license revocation or long-term suspension. This sentence for first offenders in Maryland is typical and usually comes with a requirement to attend an alcohol education program and a lecture from the judge as to what penalty would confront her should there be a reoccurrence. For most people, the uneasiness, expense, ignominy, and lecture from the court deters future drunk driving. One would think Miss Uger learned her lesson in 2007. In 2008, before the ink had dried on Miss Uger's probation contract, she was arrested in the Commonwealth of Virginia and charged with driving under the influence of alcohol. She had an alcohol level of 0.08 or above, which is above the legal limit. Her case was plea bargained down to a reckless driving offense, for which she received no jail time. A mere 3 years later, in 2011, Miss Uger chose to drive drunk again, selfishly putting her drinking and driving desires and habits ahead of the public's safety. This time she violated the drunk driving laws in a third jurisdiction. She was assessed a fine once again and maybe received a stern warning from the court. Karen Uger certainly had the hang of working the system by 2011. And all prior warnings had gone in one ear and out the other. Maybe getting caught for driving drunk was expensive and time-consuming, but she remained undeterred. The purposes of sentencing are: 1, adequate and justified punishment for the offense and offender; 2, protection of the community; 3, deterrence of the offender and other potential offenders; and 4, rehabilitation. So what should her sentence be for driving drunk this time? Maybe a higher fine than before? A more intense alcohol treatment program? And a lecture from me that if she commits a 5th offense, she very well could go to jail. Would a sentence along these lines really be in the best interest of the people of the state of Maryland? Would it deter anyone, including Miss Uger, from driving drunk? Would the public be safer when traveling on our roads? The case before us today occurred on March 19th of 2024. The defendant's 4 drunk driving offenses have spanned a 17-year period. Can we believe that she's only driven while intoxicated 4 times in the last 17 years? Or is it more likely that she's been very lucky and her inebriation has gone undetected? The court will neither consider the defendant's celebrity status nor the inane statement she made both at the accident scene and while in the police car after her arrest as a basis for enhanced punishment. She was filled to the gills with alcohol. After Miss Uger was arrested in March of 2024 on this case, she spent 6 days at the Maryvale Resort in Arizona. Not a rehabilitation or counseling center, but a luxury spa. After the jury convicted her of driving under the influence of alcohol in December of 2024, and 18 years after her first alcohol-related conviction, she sought treatment at the Beachside Recovery Center in West Palm Beach, Florida. The state correctly points out that the brochure describes the Beachside Recovery Center as a resort. She is currently enrolled in the Sun Cloud Health Outpatient Program. How about a program without a summer vacation connotation? Ms. Huger is finally addressing her substance addiction. Better late than never. Her treatment will help her rehabilitate herself if she sincerely wants help. Time will tell. What's the guarantee she's done driving while drunk? Unfortunately, there is no guarantee. Ms. Huger is a very accomplished television personality and entrepreneur. She's the mother of 2 very successful young adults. She's been involved in several impressive civic programs which have substantially aided her community. However, if while driving drunk, Karen Huger had struck a child who was in that pedestrian crossing, killing that child, does anyone think the child's parents would be consoled if told the drunk driver was a reality TV star, a good mother, and had volunteered for several community projects? Logic tells us that if we continue doing the same thing, we will keep getting the same result. We need to help Ms. Huger break this dangerous and destructive pattern and at the same time protect the public. This case demands a different outcome. The guidelines offer the court a wide sentencing range. The floor is probation and the ceiling is probation. If there was ever a time to label guidelines as ludicrous, this is the time. Would it take a 5th, 6th, or 7th alcohol-related violation before the guidelines would recommend stronger medicine than probation? I agree with the state's position based on all the documents I've been giving in the law that the maximum sentence allowed in this case is 2 years. Please stand up, Ms. Huger. The sentence on this court on count 1, driving under the influence of alcohol, is that you serve 2 years at the Maryland Department of Corrections with 1 year suspended. You will serve your 1 year time at the Montgomery County Correctional Facility. You will pay a fine of $2,000. Upon release, you'll be on probation for 5 years. After 3 years, if you have complied with all the conditions of probation, the remaining 2 years will be unsupervised. The conditions of probation are as follows. You must be supervised by parole and probation. Your probation begins upon release from jail or incarceration. Your first appointment with the supervising agent is 2 days after your release from jail or incarceration. And the address is on the sheet. You must report as directed and follow your supervising agent's lawful instructions. I have excluded 2 about work or attend school. I've excluded 3 about getting permission from your agent to change your address. So I've excluded 2 and 3. You must obey all laws. You must notify your supervising agent if you're charged with a criminal offense, including a jailable traffic offense like this. I've excluded 6, which deals with owning dangerous weapons. You must permit the agent to visit your home. 8 is really superfluous. It says you can't possess or sell or drug drugs or alcohol, etc. That would be a violation of obey all laws that's in there. You must appear in court when notified to do so. There are special conditions of your probation, which I'll address momentarily. Your total, we'll get to that in a minute. Special conditions are as follows. You will not be able to allow to drive any motor vehicle for 1 year after your release from incarceration, regardless of what the Motor Vehicle Administration permits. That starts that year after you're released, after you serve your 1-year sentence. When you resume driving, you will not drive with any alcohol in your system. Upon release, you must have an operable interlock system installed in any vehicle you drive for the duration of your probation. You will enroll and make every reasonable effort to complete any alcohol education and treatment program ordered by your probation agent. On count 2, failure to reduce speed, I sentence you to a $500 fine. On count 3, failure to notify MVA of the change of address, I fine you $100. On count 4, negligent driving, I sentence you to a $300 fine. The total fines are $2,900. That must be paid at the clerk's office. Court's cost you must pay. That's to be determined by the clerk. You'll have to pay a supervision fee of whatever it is. I think it's currently $50 per month. I didn't overlook the other things the state suggested, and maybe Mr. Martella in my conditions of probation, but I am not ordering them. Ms. Uger, you have 30 days. You have an absolute right to appeal this case. You have 30 days to note an appeal to the Appellate Court of Maryland. You have 90 days within which to ask me to reconsider my sentence. I can lower it, I can keep it the same, but I can't increase it. You have no right to a 3-judge panel because the overall sentence did not exceed 2 years. The 2 rights that you do have, the 30 days within to note an appeal, must be done within 30 days. Mr. Martella, who's as versed in the law as anyone in this county, can tell you the pros and cons of that, and same with the 90-day request to reconsider your sentence. You can take advantage of both of those rights, 2 of those rights, or 0 of those rights. It's your decision. If you ask for a reconsideration of sentence, that has to be acted upon within 5 years. All right. Is there anything that I didn't address, state or defense?
No, Your Honor, and just confirming
Pardon?
Just confirming, obviously, there was no probation before judgment offered.
Not even close.
Okay, just confirming for the record.
Did I ask? I didn't
Yes.
ask.
Yeah.
As I understand your order, she's not to drive a car for 1 year after she's released.
Correct.
And
Regardless of what the Motor Vehicle Administration says.
right. And then, is it true that then, after that year is done, then she installs the interlock?
Correct, for the remainder of her probation.
Gotcha. Okay.
The probation does not start today. It starts upon release after serving the 1 year.
Right. Okay. Thank you.
All right. Everybody did a nice job. This court will stand in recess.
All right. We're going to recess.